Roger B. Taney by Kaley and Jaden. Background: Roger B. Taney's full name is Roger Brooke Taney. Roger B. Taney was born in Calvert County, Maryland. Roger B. Taney was born on March 17, 1777. Early life: Roger B. Taney was one of 6 kids. Because Roger B. Taney wasn't going to inherit anything from the family, he decided to pursue his own career in law. Education: Roger B. Taney was educated at Dickinson College in Pennsylvania at the age of 15. Roger B. Taney passed the bar test to become an attorney in 1799. Roger B. Taney was a Federalist and became very educated in politics, later becoming a member of the Maryland House of Delegates. Roger B. Taney served only 1-year term for the Maryland House of Delegates in 1799. Career: Roger B. Taney then became a member of the Maryland Senate and served a 5-year term for the Federalist Party. Roger B. Taney became the U.S. Attorney General in 1831, and from there he was appointed Secretary of Treasury in 1833 due to disobeying orders from the previous secretary. Roger B. Taney was then a Maryland Attorney General for the Democratic Party for 5 years. Road to being chief: Roger B. Taney was nominated as U.S. Associate Justice in 1835, but was disapproved by Senate. Roger B. Taney then was nominated for Chief Justice following the death of a Chief Justice, John Marshall, and Senate approved. They, slaves and their descendants, are not included, and are not included, and are not intended to be included under the word citizens in the Constitution, and can therefore claim none if the rights and privileges which that instrument provides for and secures to citizens of the United States. The Negroes have never been, will not, and cannot be citizens of the United States. They have no right which the white man is bound to respect.
Hustler Magazine versus Falwell. This case was brought up in 1983 at the United States District Court of Virginia. An ad parody in Hustler Magazine brought up this lawsuit. The ad was for Campari Liquor. Campari Liquor was running an ad campaign talking about a celebrity's first time. The specific ad talked about Jerry Falwell, an evangelical Southern Baptist pastor, televangelist, and a conservative political commentator. The ad included a fake interview with Falwell's first time being with his mother. A part of the ad had Falwell saying, "I never really expected to make it with my mom, but then after she showed all the other guys in town such a good time, I figured, what the hell." The whole thing was a joke. The ad was funny to some people, but extremely repulsive to others. The case went to Supreme Court because the ad tested the limits of the First Amendment and tort law. Part of the First Amendment gives us the freedom of speech and the freedom of the press, both in which were abused in this case. Tort law is a body of rights, obligations, and remedies that are used by courts in civil cases to provide relief for someone who has suffered harm from a wrongful act by someone else. Falwell sued Hustler Magazine because the ad put a bad image on him, invaded his privacy, and because there was intentional infliction of emotional distress. The jury didn't agree on the intentional infliction of emotional distress claim, but they did believe that he should be awarded $100,000 in compensatory damages, as well as $50,000 in damages from petitioners. This was the first time a public figure used tort law to punish a publisher for publishing offensive and hurtful content.
What it do, baby boo? Yeah, little mama, you looking good.